come to the other laws, and particularly which affect the transgenders. Section 377 is not the only example of problematic colonial legacy pertaining to sexual minorities remaining on the statute books. There was a Criminal Trials Act 1871. This was enacted in colonial India to police those tribes and communities who, according to the British, were addicted to the systematic commission of non-bailable offences. So just belonging to one of those communities meant that the individual was deemed to be a criminal. If you are, unfortunately, you are born in that community, then there are various communities, particularly in Maharashtra and some other areas. So you are regarded as criminal. You have to go to the police station regularly to give your attendance, because having born in that community is a crime. Now in 1897, this act was amended to include eunuchs. The government had to keep a register of all eunuchs who are reasonably suspected of kidnapping or castrating children or of committing offences under Section 377. Nehru, in 1936 speech, famously called the act atrocious, arguing for its repeal, saying that the whole principle as such is out of consonance with civilized principles of criminal justice and treatment of offenders. Despite its eventual repeal, and for the longest time, the Hijra community was still criminalized. Prosecution also remained, but the Nalsa judgment came, and which is, according to me, was a game changer. In Nalsa versus Union of India, the Supreme Court recognized transsexuals as a third gender. At its heart, the judgment accepted that the non-recognition of Hijras, transgender persons, denies them equal protection of law, thereby leaving them extremely vulnerable to harassment, violence and sexual assault. Contrary to Koshal, the court interpreted sex, the word sex is used in Article 15. No person can be discriminated on the ground of various grounds, place of birth, religion, etc. So sex is one of the grounds. So in NAS we read sex may include sexual orientation, and the NALSA also affirmed that, and they further said, sex would include gender identity to establish a violation of right to equality. It also extended freedom of speech and expression to encompass values of privacy, self-identity, autonomy and personal integrity. NALSA said even if law were facially neutral, it would be unconstitutional if it had a direct disparate impact and discriminating trend. This was one of the arguments before us in NAS Foundation. They said the law applies to everyone. It's not necessarily directed against homosexuals or any other particular community. Because it's whosoever indulges in a sexual act against the order of nature would be punished. So this was completely wrong, because it actually affects a particular community, and thus it violates the equal protection of law. The Supreme Court then, in unconnected privacy case, they said that they identified decision in Koshal as one of the discordant notes. So many of these ideas were developed by the court in Naute Johar. For example, the judgment, and this is very important, I must give some importance to this. See what the Chief Justice Deepak Mishra's judgment said. So sexual orientation can be a natural orientation. So it should be protected, person should not be discriminated on that ground, that's okay. But it is also a matter of choice. It is also a matter of self-determination. It's not only, both things are important. That particular orientation, natural orientation of a person and choice is equally important. The Chief Justice concluded that Section 377 disrespects individual choice, making it both irrational and manifestly arbitrary, and thus violates Article 14. Justice Chandrachud critically observed that members of the LGBTQ community are entitled, as all other citizens, to the full range of constitutional rights, including the liberties protected by the Constitution. With the Supreme Court accepting that homosexuality is not a criminal activity, there is no turning. But here, the court also recognizes that decriminalization is only the beginning. This is not the end of the matter. So the section 377 is no longer applicable to this LGBTQ community, but this is only a start of the years of stopping the injustice to be done to them for centuries. The journey is long and arduous and will involve turf wars of all kinds of basic civil rights, whether it is right to education, housing, and access to services and marriage. I mean, gay marriages. I mean, I'll come to it slightly later. But unlike the situation 10 years ago, the destination is now visible and perhaps even within reach. Many countries have changed their laws or set procedural precedent to ensure that stigma against LGBTQ persons is removed and that non-discrimination and fair treatment are truly available to all. This has been placed in at least 3 ways it has been done in recent decades in different parts of the world. I'll just tell you how this has been achieved by various governments of different countries. The first way has been to provide for this in the constitution itself. For the first time in history, South Africa's post-apartheid constitution was drafted to forbid discrimination on the grounds of sexual orientation. It is interesting to note, Dr. Bhutia referred to Mr. Nelson Mandela. So it's interesting to note that Mr. Nelson Mandela, under whose watch the constitution was drafted, was not pro-gay rights to begin with. But his opinion was changed after discussions with the younger ANC leadership to concede that gay rights are the same as human rights and no discrimination could be acceptable. Other countries have done the same in their constitution, the recent constitutions like Fiji, Ecuador, and Bolivia, etc. The second way has been by reading fundamental protections expansively. So what you do is you read the discrimination clause expansively, like a person cannot be discriminated on ground of sex. So you read that word sex in an expansive way. So these are analogous grounds for discrimination. So this is really, it started in Canada, by Canadian Supreme Court. In Eagle versus Canada, the court extended the analogous grounds doctrine to LGBT persons as well. Our Supreme Court has accepted this in NALSA, powerfully concluding that discrimination on the basis of sexual orientation or gender identity includes any discrimination, exclusion, restriction, or preference which has the effect of nullifying or transposing equality by the law or the equal protection of laws guaranteed under our constitution. The third way has been by passing or amending national laws that explicitly prohibit discrimination against LGBTQ persons. Examples of this abound, notably in the United Kingdom, Australia, and New Zealand. The UK's Equality Act 2010 includes sexual orientation and the gender reassignment as protected characteristics, and the law applies to areas as diverse as employment, pension benefits, and education. Wherever basic rights of LGBTQ persons have become entrenched and recognized, jurisdictions have moved on to explore how such persons can be mainstream into society, and that is what is not happening in India. So we are unable to mainstream the LGBT community amongst our society. After recognizing same-sex relationship, the next step has to be recognized of formal civil unions and partnerships between same-sex individuals, leading eventually to the recognition of marriage. The underlying principle is not to provide any kind of special status to any group of persons. By recognizing, you are not providing any special status to a same-sex couple, but all that you are acknowledging is social institutions like marriage, child rearing, and family life are neutral to sexual orientation or gender identity. The issue of same-sex marriages is already pending before the Delhi High Court. Unfortunately, the central government through the Home Ministry has taken the stance that same-sex marriages will cause havoc with the delicate balance of personal law. The same argument was advanced in Nas Foundation in 377. The same about the public morality. However, in the light of the Supreme Court decision in Nautesh Johar, the Delhi High Court would find it difficult, if not impossible, to take a negative view on such marriages. The 2015 US Supreme Court decision in Obergefell versus Hodges is relevant here. The petition challenged laws in 4 states in the US which defined marriage to be only a union between man and a woman. The court concluded that the fundamental constitutional right to marry is guaranteed even to same-sex couples, thus overturning a 1971 decision and effectively legitimating same-sex marriages throughout the country. Ladies and gentlemen, we are at a juncture where the legislature has to step in and play its role. It has tried that with the Transgender Act, which the Parliament legislated upon after a few earlier iterations, although with disastrous results. Now, let me just tell you about this Transgender Act, which has been introduced, which has been passed last year, in 2019. Now, any law that seeks to address the rights owed to transgenders must recognize the grave wrongs that have been done to them. Merely for their identity, they have been killed, raped, stripped naked, and brutalized to a degree that is indescribably horrific and traumatizing. The first step of recognition surely is to consult with the affected stakeholders, that is, the transgenders themselves. But the consultation for the 2019 Act was thoroughly inadequate. Indeed, the bill itself was not made available to public till the day it was tabled in the Lok Sabha. Naturally, for a law that was made without appropriate consultation, it has several problems. Several definitions are redundant and inapplicable to the issues of the community. Take, for example, the word definition of family. It is simply blindly borrowed from some other earlier laws. This is without understanding the relevance of family to the transgender community. Most transgenders do not live with their biological family due to discrimination and violence. Thus, the idea of chosen family becomes relevant, since the chosen family provides support. The chapter on discrimination against transgender ought to be centerpiece of that. But it has its own set of problems. There is no enforcing authority. There are no remedial measures by way of compensation or otherwise for survivors. And there are no serious punitive measures against the violators. The National Council for Transgender Persons, which is constituted under this Act, comprises of 30 persons, of which merely 5 are transgenders, and they are to be nominated not by the transgender community, but by the government. So this council again has no meaning. Prime Minister Narendra Modi has on occasion acknowledged that transgenders have been treated unjustly in India, and that the government needed to change its outlook, including those changes to its laws and regulations. But changes are meaningless if they fail to recognize the real issues that are faced by the transgender community. Even so, we must remember that the battle to safeguard the rights of LGBTQ persons will not be won simply by political or judicial action in removing a certain law or legal regulation or creating a new legislation. The battle will be finally won when everyone in India, in cities or villages, in police chowkis and hospitals, will truly believe that LGBTQ persons are no different, and they have the same capacity to love, build long-lasting relationships, and be good parents as everyone else. On our part, we can help by spreading awareness and by treating LGBTQ persons with equal kindness and consideration. Ladies and gentlemen, I believe a couplet from the great Persian poet, mystic poet, Rumi captures succinctly what I have been trying to tell you all evening, and I'll just narrate those 2 lines. Listen with ears of tolerance. Listen with ears of tolerance. See through the eyes of compassion. Speak with the language of love. Thank you.